Last year there were dissents or separate opinions in 2 out of every 3 opinions that the U.S. Supreme Court handed down. This year the percentage is likely to be higher given some really high profile, high tension cases that are coming up. But we're used to that. This has been the pattern ever since the early 1940s. Before that, believe it or not, there were very few dissents at all. Up until the 1940s, the Supreme Court was unanimous in 95% or better of all their cases every term. We started out with an English heritage of seriatim opinions. That is, every judge would write an opinion on the case. The problem here was that while you could tell who won by counting up the votes, you couldn't always tell what the reason was that the person had won. John Marshall believed that it would be better for the court if it spoke in one voice. Now remember, this is the beginning of the Republic, and what he's trying to do is establish the court as a co-equal branch of government. And by the force of his personality and his logic, this is what happened. And this is still the belief of some jurists, that a court should speak in one voice because it carries more weight that way. In Europe, some countries have up until recently actually forbidden the publication of dissents. Now, there were dissents from the beginning, but few and far between. In the 19th century, the only important ones were the 2 dissents by McLean and Curtis in the Dred Scott decision, and they didn't have a great impact in some ways beyond a few years because the Civil War settled the issue. Stephen Field in the Slaughterhouse case had an enormous impact and got us to treat corporations as if they were persons. And then there was John Marshall Harlan I in the civil rights cases, which continues to have an impact unto this day. Moreover, even if a justice did not agree with the majority opinion, well into the 1920s he, and they were all men at this time, might often just note disagreement without a separate opinion. One reason was that up until the mid-1920s, the court heard almost every kind of case. Cases that today would be decided in a magistrate's court, in a local township, maybe a low state court. There were bankruptcy cases. There were the types, you remember that thing in Fiddler on the Roof? He sold me a horse, it was a mule, that sort of thing. Those cases actually come before the Supreme Court. They were of importance only to the people who were litigating it. And as Louis Brandeis said of these cases, it was more important to decide a case than to decide it right. Just get it out of here.